SwayamPrabha. Digital India. Educated India.
Good morning, students. My name is Shalini Sharma. I am a working child right professional having experience of more than 5.5 years as Chairperson Child Welfare Committee and 1.5 year in my present role as member Juvenile Justice Board. Today, I am here to take your course on Juvenile Justice Care and Protection of Children Act 2015, and our module for today is Offences against Children. Offences against children are described in Chapter 9 of the Juvenile Justice Act, and Section 74 to Section 79 deals with it. In our previous chapters, we have studied evolution and emergence of juvenile justice system in India. We have also studied about Child Welfare Committee, which is a statutory body under Juvenile Justice Act to look into the cases of children in need of care and protection. We have also studied about Juvenile Justice Board, which is again a statutory body to deal into the cases of children in conflict with the law. We have also studied about the institutional care or child care homes, where we have studied various kinds of homes prescribed under Juvenile Justice Act. We have also studied about non-institutional care, which is a mandatory scheme under Juvenile Justice Act, under which sponsorship foster care services are provided to the children. We have also read about the adoption, and today we will read the offences against children. Before starting with the offences against children, let's have the brief introduction of this act. The Juvenile Justice Care and Protection of Children Act 2015, most commonly referred as Juvenile Justice Act 2015, is the overreaching legislation prevailing in the India regarding protection of children. The JJ Act deals with children in conflict with the law and children in need of care and protection. It acknowledges that children falling both in these categories are children in need of care and protection. Juvenile legislation creates a separate system to handle cases of children alleged to have committed an offence whose objective is care, protection, restoration, rehabilitation and restoration of the child back into the society. So, let us understand who is a child. This act defines a child as a person who has not completed 18 years of age. The act categorizes a child into two categories: child in conflict with the law and child in need of care and protection. Although this act categorizes children in two categories, but for the sake of legal protection and consideration, it is deemed as any person who or of any gender who is aged between 0 to 18 years. So, for the purposes of the Juvenile Justice Act, child is any person of any gender who is between the age group of 0 to 18 years. Now, let us start with our module of the day, Offences against Children. Since the time immemorial, due to their inherent natural weakness, children have been the victim of criminal offences. Alongside women, they both are known as the weaker sections of the society. The crimes which are committed against children are not restricted to any specific gender or age. This is usually because of their incapacity to appreciate the nature of the offences committed against them and their consequences, thereby making them a soft target of the offender. In other words, due to their innocence and their age, they are offender's favorite victim. In this chapter, we will learn about various offences against children and also about various legislations existing for combating them. Any offence or offence committed against a child or children is or are regarded as offence against children or juveniles. The first section we will take up today is section 74. The marginal line of the section says prohibition on disclosure of identity of children. So, let us say what 74 subclause 1 says. No report in any newspaper, magazine, news sheet or audio-visual media or other forms of communication regarding any inquiry or investigation or judicial procedure shall disclose the name, address or school or any other particular which may lead to the identification of a child in conflict with the law or a child in need of care and protection or a child victim or a witness of a crime involved in such matter under any other law for the time being in force, nor shall the picture of any such child be published. So, children, here we see the Act talks about how many kinds of children. This Act says prohibition of disclosure of identity of child in conflict with the law, child in need of care and protection, third, child victim or witness of a crime. So, any information about these 4 kinds of children cannot be disclosed in any newspaper, any news sheet, any social media, visual media, magazine, etc. And also the picture of such child is also not supposed to be published. Now, let us see what the proviso says. Provided that for the reasons to be recorded in writing, the board or committee, as the case may be, holding the inquiry may permit such disclosure if in its opinion such disclosure is in the best interest of the child. So, students, here an exemption is created which says that if in the opinion of the board or committee it is felt that the publication of the information of the child is essential but in its best interest, and the order of child welfare committee or the board will be issued in this regard, and that too an explanatory order why the permission has been given for the publication of the picture of a minor. Now, let us see the subclause 2. The police shall not disclose any record of the child for the purpose of character certificate or otherwise in the pending case or in the case which has been closed or disposed of. So, there are many cases where in future the children in conflict with the law or otherwise the children will require their character certificate, but it was observed that police was always reluctant to issue their character certificate. So, the provision of this section makes it a offence. Nobody will write anything against the child about the offence he has committed as a youth or as an adolescent. It should not reflect in the character certificate. Here the word in the pending case has been recently added in the amendment 2022. So, the police is under duty to issue the character certificate to the child even if the inquiry is pending before the board, or they will issue a certificate if the child who was a child when the offence was committed by him, but now he is an adult, the character certificate will be issued
to
him even if the case has been closed or disposed of. Now let's see what are the punishments under this section. Any person contravening the provision of subsection 1 shall be punishable with imprisonment for a term which may extend to 6 months or a fine which may extend to 2 lakh rupees or both. So, if anybody willfully discloses the identity of the child, maybe he is a child victim, he is a witness, he is a child in conflict with the law, he is a child in need of care and protection, he can get a jail term up to 6 months or fine up to 2 lakh rupees or both. Now, let us see the section 75. The marginal line of the section says, punishment for cruelty to child. Whoever having an actual charge of or control over a child assaults, abandons, abuses, exposes or willfully neglects the child or causes or procures the child to be assaulted, abandoned, abused, exposed or neglected in a manner likely to cause such child unnecessary mental or physical suffering shall be punishable with imprisonment for a term which may extend to 3 years or with fine of 1 lakh rupees or with both. Now students, section 75 says, whoever is in the actual charge of the child assaults, abandons, abuse, exposes or willfully neglects the child or causes or procures the child to be assaulted, abandoned, abused, exposed either by himself or through somebody, and that abuse, assault has caused child unnecessarily mental or physical suffering or emotional suffering shall be punishable with imprisonment for a term which may extend to 3 years and a fine which may be 1 lakh rupees or with both the punishments. Now let us look at the proviso of this section. Provided that in case it is found that such abandonment of the child by the biological parents is due to circumstances beyond their control, it shall be presumed that such abandonment is not willful and the penal provisions of this section shall not apply in such case. So students, here an exception is created, but for whom? But for biological parents. If biological parents for the reasons or the circumstances beyond their control abandons their child, this will not attract the penal punishment of this section. Further, that if such offence is committed by any person employed by or managing an organization which is entrusted with the care and protection of the child, he shall be punished with a rigorous imprisonment which may extend up to 5 years and a fine which may extend up to 5 lakh rupees. Here another proviso is given, and this is for the persons employed in or managing an organization which is for the child, which is dedicated to the child, and if any such person or managing director of such institution is found to be violating, abusing, exploiting the child, he has been sentenced a rigorous imprisonment which may extend to 5 years or a fine which may extend to 5 lakh rupees. Here another proviso is given, provided also that on account of the aforesaid cruelty, if the child is physically incapacitated or develops a mental illness or is rendered mentally unfit to perform a regular task or has risk to life or limb, such person shall be punishable with rigorous imprisonment not less than 3 years, but which may be extended up to 10 years and shall also be liable to fine of 5 lakh rupees. Now here it is explained that because of the cruelty mentioned in the subclause 1, if child has become physically incapable or he has developed mental illness, or he is mentally not well to perform normal tasks, normal day-to-day life tasks, or his life or his limbs are in risk of harm, such person will be punishable with rigorous imprisonment, not less than 3 years, but which may be extended up to 10 years and shall also be liable to a fine of 5 lakh rupees. Now, let us see what the section 76 says. Employment of child for begging. Subclause 1, 76 says, whoever employs or uses any child for the purpose of begging or causing any child to beg shall be punishable with imprisonment for a term which may extend to 5 years and shall also be liable to fine of 1 lakh rupees, provided that if for the purpose of begging the person amputates or maims the child, he shall be punishable with rigorous imprisonment for a term not less than 7 years, which may extend up to 10 years and shall also be liable to fine of 5 lakh rupees. Now, section 76 says, whoever employs or uses any child for the purposes of begging or forcibly asks children to beg on the roads, this offence has been made punishable with a term which may extend to 5 years and with a fine of 1 lakh rupees. But here proviso says, if for the purposes of begging the employer amputates or maims the child or in any way harms the child, he shall be punishable with rigorous imprisonment for a term not less than 7 years and which may extend up to 10 years and shall also be liable to fine of 5 lakh rupees. Now, let us see section 76 subclause 2. Whoever having the actual charge of or control over the child abets the commission of an offence under subsection 1 shall be punishable with same punishment as provided in subsection 1, and such person shall be considered to be unfit under subclause 5 of clause 14 of section 2. Now, let us see. Here the section says, the person who is in charge of the child may be guardian, may be the biological parents, may be the fit persons who were in charge of the child at that time, and they abet with the employer or a racketeer and employ their children for begging. They will be punished with the same punishment as the employer. And a proviso is also created in this section. This says that if biological parents, guardians are found to use their child for begging, they will be declared unfit under section 2 subclause 14 of the JJ Act. And let us see the proviso. It says that the said child shall not be considered as a child in conflict with the law under any circumstances and shall be removed from the charge or control of such guardian, custodian and produced before the committee for appropriate rehabilitation. And where such child is found begging, the child should not be considered as child in conflict with the law, whereas he should be considered as child in need of care and protection and should be removed from the charge of his guardians and should be produced before the Child Welfare Committee at the earliest. Now, let us see what the section 77 says. Whoever gives, if any person is found giving or selling any intoxicating liquor or narcotic drug or a tobacco, cigarette, e-cigarettes or a psychotropic substances to a minor child shall be punishable with a rigorous imprisonment for a term which may extend up to 7 years and shall also be liable to a fine which may extend up to 1 lakh rupees. Here an exception is created if that substance is administered to a child on the order of a duly qualified medical practitioner. Now, let us see for the section 77 what the rule 56 of the Juvenile Justice says. This rule mandates that the police to inquire and file a FIR in a case of a child who was found with intoxicating liquor, narcotic drug, psychotropic substance, and instructs them to produce the child before the board or committee, except in a situation where the child is not in condition to be produced before the board and require medical attention. It is a duty cast upon the police that if a child is found in possession of intoxicating liquor, narcotic drugs, psychotropic substance, the police has to inquire and register an FIR against the seller, and also to ensure the production of the child before the child welfare committee or the board, as the case may be. And an exception is created here that only if the child is not well, he should not be immediately produced before the board, but the information has to be shared with the board or the committee. The rule has provided vast powers to the board or the committee regarding filing of FIR, inquiring the child care institutions, passing orders on rehabilitation of addicted children through rehabilitation centers, etc. So, this section gives ample powers to the child welfare committees and the boards to register FIR against the sellers of these banned substances to the children. And furthermore, the rule imposes the guidelines to the seller of such products to raise awareness among minors through inscribing the imposition of punishment of selling such substances to minors on their products as well as their shop board. So, it is made mandatory even for the shopkeepers to put a board on display that the narcotic substances will not be sold to the minors or the persons below 18 years of age. Now, let us understand this section better with a case study. Imagine a scenario where a shopkeeper sells cigarette to a group of teenagers, knowing that they are under the age of 18. One of the teenagers' parents discovers this and reports it to the police. Under section 77 of the Juvenile Justice Care and Protection of Children Act, the shopkeeper can be charged for providing tobacco products to minors. If found guilty, he could face rigorous imprisonment for up to 7 years and a fine up to 1 lakh rupees. Now, let us see what section 78 says. Using a child for vending, peddling, carrying, supplying or smuggling any intoxicating liquor, narcotic drug or a psychotropic substances. Now, whoever uses a child for vending, peddling, carrying, supplying or smuggling any intoxicating liquor, narcotic drug or a psychotropic substance shall be liable for a rigorous imprisonment for a term which may extend to 7 years and shall also be liable to a fine up to 1 lakh rupees. This section has come in response to a scenario where a minor children are used by many drug peddlers to shift their drugs or consignment from one state to another, as the minor children are easy targets and they are mostly used. Now, this section makes it mandatory that after investigation, if it is known to the police that the mastermind is someone else, he can be booked under this section. Rule 57, Juvenile Justice Model Rule, deals with the procedural aspects involving section 78. Now, let us understand them. The police have the duty to inquire the child and filing a FIR in the case of the child found to be vending, supplying, carrying out or smuggling the intoxicating liquor, narcotic drug, psychotropic substance. Now, if a child is found in possession of these banned substances, the police have to inquire and register a FIR against the perpetrator, the mind behind this consignment. The police, it is the duty cast upon the police to inquire and file an FIR against the perpetrator. Rule 57, subclause 2. It emphasizes on producing the child before the board or the committee in the case the child is in need of care and protection. It is also a duty cast upon the police. If any child is found peddling these banned substances or using or transferring, they have to report the matter of the child to the committee or the board. Now, let us understand this with an example. Imagine a situation where a shop owners employ a 14-year-old boy to deliver packages to his customer. The child was not aware that these packages contain illegal narcotics. The police conduct a raid and find a child in possession of these substances while making a delivery. But an investigation in the matter reveals that shop owner has been using child to smuggle drugs under the guise of delivery. Under section 78 of the Juvenile Justice Care and Protection of Children Act 2015, shop owner would be charged for using a child in the illegal trade of narcotics, not the child. And the child in this case will be declared as child in need of care and protection and will be produced before the board or the committee as the case may be. In the case of Bachpan Bachao Andolan versus Union of India, the Indian Supreme Court highlighted the need of comprehensive policy to tackle the drug abuse among children. As we know, this is a growing scenario amongst our youth. Through establishing a standard operating procedure and enforcing the provision of section 77 and section 78 of the Juvenile Justice Care and Protection Act. So, in the Bachpan Bachao Andolan versus Union of India, Supreme Court observed that the mandatory provisions of section 77 and section 78 should be enforced in the interest of the youth. Exploitation of a child employee, section 79. Notwithstanding anything contained in any law for the time being in force, whoever ostensibly engages a child and keeps him in bondage for the purpose of employment or withholds his earnings or uses such earning for his own purposes shall be punishable with a rigorous imprisonment for a term which may extend to 5 years and shall also be liable to fine of 1 lakh rupees. Here the section says, if anybody makes a minor work forcibly or hold him as a slave or hold his earnings all by himself, can be booked under this section with a rigorous imprisonment for a term which may extend to 5 years and shall also be liable to fine of 1 lakh rupees. Now, explanation of this section is given. For the purpose of this section, the term employment shall also include selling goods and services and entertainment in public places for economic gain. Here, employment is explained. Selling goods and services. We all have seen small children working in the tea shops. Now, if anybody employ these small children for selling goods and services, they can be booked under this section, and for entertaining in public places for economic gain. We have seen children working in the circus or working or dancing on the roads or performing their acts on the roads, so for economic gains. So, all these activities have been made offence under section 79. Nobody will use the child or his performances for their own economic gains. Punitive measure for adoption without following prescribed procedures, section 80. So, with coming up of 2015 Act, this section was introduced. This section is for an individual and also is for an organization. If a person or an organization offers or gives or receives any orphan, abandoned or surrendered child to adoption without following the laid procedures in the Juvenile Justice Act, shall be punished with an imprisonment of either description of a term which may extend up to 3 years or with a fine of 1 lakh rupees or with both. Now, let us see what the proviso of this section says. In case where the offence is committed by a recognized adoption agency, in adoption to the above punishment awarded to the person in charge of and responsible for the conduct of the day-to-day affairs of the adoption agency, the registration of such agency under section 41 and its recognition under section 65 shall also be withdrawn for a minimum period of 1 year. So, here the liability is increased. It says if this offence is committed by any recognized adoption agency, that means any agency which is recognized with government or the state government, and the person in charge of such agency is found guilty of this offence, his punishment will be increased and the registration will be taken back from that agency. Section 81. Sale and procurement of children for any purposes. Here the issue of child trafficking is tackled. Any person who sells or buys a child for any purpose shall be punishable with rigorous imprisonment for a term which may extend to 5 years and shall also be liable to a fine of 1 lakh rupees. The section is very clear. Whoever, any person who tries to sell or buys a child for any purpose shall be punished with a term which may extend to 5 years and also with the fine of 1 lakh rupees. Provided that where such offence is committed by a person having actual charge of the child, including employee of a hospital or a nursing home or a maternity home, the term of imprisonment shall not be less than 3 years and may extend up to 7 years. Here a proviso is given which says that a person who was actual in charge of the institution where the child was placed, like a hospital where child was born or a child care institution where child was placed, he is found to have committed of selling or buying a child, he shall be sentenced with a term of imprisonment shall not be less than 3 years and it may extend up to 7 years. Section 82. Corporal punishment. Any person in charge of or employed in a child care institution who subjects a child to a corporal punishment with the aim of disciplining the child shall be liable on the first conviction to a fine of 10,000 rupees and for every subsequent offence shall be liable for imprisonment which may extend to 3 months or a fine or with both. So, section 82 subclause 1 says that any person who is in charge or employee of a child care institution subjects a child to a physical punishment, maybe with the aim of disciplining or correcting the child. On the first conviction, he will be given a fine of 10,000 rupees. But if he repeats his offence again, he will be liable for imprisonment which may extend to 3 months or with a fine or with both. If a person employed in an institution referred to in subsection 1 is convicted of an offence that under subsection, such person shall also be liable for dismissal from service and shall also be debarred from working directly with children thereafter. So, here this clause talks about that if a person is an employee of an institution who was supposed to take care of the child and he involves in the corporal punishment of a child, such person shall be dismissed from his service. He will not be allowed to work in that institution anymore and he will also be debarred from working with children or child care institutions anywhere else in future. Now, let us see what the rule 60 of model rules 2060 says with regard to this section. It says every child care institution to mandatorily have a complaint box at a prominent place so as to facilitate the reporting of cases involving corporal punishment by the child or anyone on his or her behalf. So, this rule says that there should be a complaint box and it should be at such place where it could be easily seen by the children. And if a case of corporal punishment is there, child can himself drop a letter or anybody else about that incident can drop a letter in the complaint box. And rule 60 subsection 3 says that the complaint box will be opened in the presence of district child protection unit once a month. Every month that complaint box will be checked to ensure that in that institution there is no incident of corporal punishment. Rule 60 subclause 4 and 60 subclause 5 empowers that a judicial magistrate, a first class nearest to the child care institution to adjudicate such matters and ordered the child welfare police officer to take appropriate measures on receipt of such complaint respectively. And now here a duty is cast upon the district child protection unit. If they receive a complaint about the corporal punishment, they have to share the report with the judicial magistrate nearest to that institution, and the judicial magistrate will ask the concerned child welfare police officer to investigate the matter. The board or the committee under rule 60 subclause 6 has the power to transfer the child to another child care institution for the best interest of the child. So, if a report of corporal punishment is received by the child welfare committee and the board keeping the best interest of the child in mind can shift such child to any other child care institution. In fact, the management have to abide by the directions given by the board, committee and state government under rule 60 subclause 8. In the event of any incident of corporal punishment in the child care institution and in case of non-compliance, the board on its own or on the complaint of the committee or the state government shall direct the registration of an FIR under subsection 3 of section 82 of the Act. So, this clause says that if an incident of corporal punishment is reported, the management of the home has to comply with the directions of the board, committee and the state government and have to facilitate the inquiry of the incident. Now, section 83, use of a child by a militant groups or other adults. Section 83, subclause 1. Any non-state self-styled militants, groups or outfits declared as such by the central government if recruits or uses any child for any purposes shall be liable for rigorous imprisonment for a term which may extend to 7 years and shall also be liable to a fine of 5 lakh rupees. This section says if any band, outfit, self-styled militant group, organization recruits a child for their work, maybe for kitchen work or maybe to transfer things from here to here, if any such report is with the police, they shall be, the person or the outfit will be punishable with an imprisonment which may extend to 7 years and will also be liable to a fine of 5 lakh rupees. If any adult or an adult group uses a children for illegal activities either individually or as a gang shall be liable for rigorous imprisonment for a term which may extend to 7 years and shall also be liable to fine of 5 lakh rupees. Now, this says if a group of an adult or a single adult uses a child for illegal jobs or illegal activities, they shall be sentenced with a rigorous imprisonment which may extend to 7 years and shall also be liable to a fine of 5 lakh rupees. Kidnapping and abduction of a child, section 84. So, this is a very innovative section of the Juvenile Justice Act. Now, let us see how. For the purpose of this Act, the provisions of section 359 to 369 of the Indian Penal Code shall mutatis mutandis apply to a child or a minor who is under the age of 18 years, and all the provisions shall be construed accordingly. Now, in this section, the provisions of section 359 to 369 of IPC shall apply as it is. Kidnapping and abduction have not been separately defined under section 84. Although under kidnapping under Juvenile Justice Act is non-bailable and kidnapping and abduction under IPC is a bailable. So, Act is very clear. If any child is kidnapped, the provisions of the IPC will apply as. Offences committed on disabled children, section 85. It says, whoever commits any of the offences referred to this chapter on any child who is disabled as so certified by the medical practitioner, then such person shall be liable to twice the penalty provided for such offence. So, section 85 talks about the twice the penalty. This says, if the offences mentioned under this chapter are done with a child who is a specially abled child and is also certified by the doctor that a child is a specially abled child, the punishment in such cases will be double. It will double or twice the penalty mentioned in that section if the offence is committed with a disabled child. Now, let us see section 86, classification of offences and designated court. Where an offence under this act is punishable with the imprisonment for a term of more than 7 years, then such offence shall be cognizable and non-bailable. When an offence committed under this act attracts a punishment of more than 7 years, then that offence will be cognizable and non-bailable. That means the police can make arrest without warrant in this case if offence attracts a punishment of more than 7 years. Where an offence under this act is punishable with imprisonment for a term of 3 years and above, but not more than 7 years, then such offence shall be non-cognizable and non-bailable. Now, if the offence is committed with the child attracts a punishment of more than 3 years, but not more than 7 years, then that offence will be a non-cognizable and non-bailable. That means to arrest him a warrant is required, but the bail will not be provided to the person immediately. Where an offence under this act is punishable with imprisonment for less than 3 years or with fine, then such offence shall be non-cognizable and bailable. But the important thing is that any offence committed under this act will be triable only in the children's court, not in any other court, which is also a court of session. Section 87, abetment. Whoever abets any offence under this act, if the act abetted is committed in consequence of the abetment, shall be punished with the punishment provided for that offence. Now, section 87 says that if the person has not committed the offence himself, but has caused somebody, but have motivated or encouraged somebody to commit the offence, and in consequence of that abetment the offence has been committed, the abettor will be getting the same punishment as mentioned in the act. Section 88, alternative punishment. Section 88 says, where an act or omission constitutes an offence punishable under this act is also an offence under any other law for the time being in force, then notwithstanding anything contained in any such law, the offender found guilty of such offence shall be liable for punishment under such law which provides punishment which is greater in degree. Now, let us study a case study to understand this section better. Let's consider a hypothetical case where a store owner employs a 13-year-old boy and makes him work for long hours, which is against the labour laws as well as the Juvenile Justice Care and Protection of Children Act. If the labour laws prescribe a fine of ₹1,000 and for such an offence, the fine prescribed under Juvenile Justice Act is ₹10,000, and according to section 88, the store owner would be liable to pay a higher fine of as prescribed by the Juvenile Justice Act, since it provides for a greater degree of punishment for the offence. Now, the section 88 says, if there are two punishments for the same offence, the punishment with a higher degree will be implemented. Section 89, offences committed by the child under this chapter. Section 89 says, any child who commits any offence under this chapter shall be considered as a child in conflict with the law under this act. So, if a child breaks any law mentioned in any part of this act, they will be treated as a child in conflict with the law and their all child rights will be protected. Now, let us see some landmark judgments where a duty has been cast upon the caregivers, stakeholders to be cautious when dealing with the cases of children. The Delhi High Court issued a fine of ₹10 lakh on a 12 media houses for disclosing the name of the minor rape victim as well as other details, including the usage of photographs of the victim, which led to the disclosure of her identity. And those 12 media houses include the big names as Times of India, Indian Express, etc. In the case of Priyanka Nikam versus State of Maharashtra, the Bombay High Court rejected the anticipatory bail application of the appellant on the grounds of committing an act of a cruelty by a person in charge of child care institution, and the High Court opined that there is need for regulation of child care centres to prevent incidents of cruelty. In Brahmanand Mishra versus PIO KVS Lucknow, the Central Information Commissioner has emphasized on removal of employees involved in the case of corporal punishments from working with children, as well as ensuring children a violence-free environment in schools and child care institutions. In this case, the Central Information Commissioner recommended that if any person is found guilty of inflicting corporal punishment on children, he should be immediately removed from the school or the institution, as the case may be, to make it a free space for the children. In another case, Learned Court observed, a teacher proved to be guilty of cruelty cannot be given in any work associated with children. It is mandatory to dismiss him. If the management does not cooperate, the person in charge of the management will be made liable to imprisonment for 3 years and also for the fine, which may extend to 1 lakh rupees. The lawmakers took serious note of the corporal punishments and does not want such teachers to be associated with students anymore. So, conclusion. In this chapter, we have seen that offences against children have been covered in a separate chapter to create an awareness and a deterrence in the society to be cautious of committing crime against the children. Other offences against children is covered under chapter 9 of the Juvenile Justice Act. Certain offences under this act are cognizable and others are non-cognizable. Certain offences are non-bailable and others are bailable. But all these offences are triable by the children courts only. So, if any matter comes to the knowledge of the police that an offence against the children as mentioned in the Juvenile Justice Act is committed, the court or the challan will be presented only in the children's court. If an offence committed against a disabled child under this chapter is punishable by twice the penalty provided for such an offence to ensure the rights of the children, and this section makes it mandatory that if an offence is committed against a child who is a specially abled child, the punishment will be doubled for the offender. We also made note of few judgments from the honourable courts which reiterate the intentions of the Juvenile Justice Act, that the innocence of the children should be protected at all costs and caregivers and guardians should be exercise due caution when dealing with the children. So, quick recap of all the sections we have studied in this chapter today. Section 74, which prohibits on disclosure of identity of children. Section 75, which speaks about the punishment of cruelty to child. Section 76, employment of child for begging. Section 77, penalty for giving intoxicating liquor or narcotic drugs or a psychotropic substance. Section 78, using a child for vending, peddling, carrying, supplying or smuggling any intoxicating liquor, narcotic drug or a psychotropic substance. Section 79, exploitation of a child employee. Section 80, punitive measures for adoption without following prescribed measures. Section 81, sale and procurement of children for any purposes. Section 82, corporal punishment. Section 83, use of child by militant groups or other adults. Section 84, kidnapping and abduction of child. So, children, today we have studied all the offences against the children explained in the Juvenile Justice Care and Protection of Children Act. We must understand a special section for the offences against the children have been incorporated under this act because the Juvenile Justice Act, Care and Protection of Children, recognizes that children are vulnerable, they need protection, and Juvenile Justice Act is a benevolent legislation which works on the rights and needs of the children. It ensures that no child is fallen out of the safety net of the society, and it is the duty of all the stakeholders like police, like caregivers, like school teachers, like co-students who are staying with the children in the child care institution to report any child right offence, any child right violation, if any wrong is happening with the child anywhere in the society. It is the duty of all the citizens, including us, to raise a voice, to stop violence against the children, because children, because of their inherent weakness, sometimes cannot raise voice for themselves. So, it is duty of all of us. No society can grow leaving their children behind. So, a society should be like a open balloon for children so that they can take a flight, they can take a leap of faith, they can trust people. But in many cases we see the horrific incidents reporting from child care institutions where we find children injured, died, and we society sleep next day like normal. We should raise a voice, we should become aware, we should acknowledge that children are vulnerable, they need care, they need protection, they need love and they need treatment. So, all these offences which I explained today, I expect all of you to know them by heart, so that when we see any shopkeeper selling a tobacco product to the child, we can raise a voice. If you find a shop who sells narcotic drugs, tobacco, cigarettes, and he did not have a hoarding which says that these products will not be sold to a minor, you should raise a voice, because we, the students of India, are big in number, and if we want to bring a change, we can. And with this positive note, I will conclude my chapter for today. Thank you so very much for your patience and listening to me. Thank you.
Hello, I am Shikha Dikshit. I teach psychology and I am with the Department of Humanities and Social Sciences at IIT Kanpur. Today I am going to talk about what is social cognition. Social cognition is a research area in psychology which explicates the various cognitive processes that people employ to understand the social world. So, essentially it is about sense making of the social world, which involves understanding other people as well as understanding oneself. Understanding others requires understanding their traits, their internal tendencies, their contextual aspects, motives, feelings, emotions, etc. So, as we can see, this is a very complex process and requires a massive amount of information processing. Even for small decisions, for simple decisions, people have to process a large amount of information. The main perspective or the approach which is used in social cognition is obviously the cognitive approach, and which is the study of mental structures and processes. The main paradigm which is used is the information processing paradigm. As far as the range of topics in social cognition is concerned, the range is very wide, from individual level sense making to collective sense making. As far as views of cognitive sense making are concerned, there are three major dominant views in social cognition: the naive scientist view, the cognitive miser view, and the motivated tactician view. The naive scientist view emerged from research done in causal attribution, and this refers to detailed and systematic processing of information and sense making in the social world. However, it is not always possible to make detailed engage in detailed cognitive processing, and hence people act as cognitive misers in many situations. So, whenever there is lack of time and cognitive effort is less, then people involve in using certain strategies which are functional, yet they are like mental shortcuts. So, this is the cognitive miser approach. However, the question that comes to the fore is that which one of the two strategies is more important? The answer is provided by the motivated tactician view. And according to this view, people can either use the naive scientist approach or the cognitive miser approach as and when required, and they can switch over between the two approaches when required. So, these are the three major views which are utilized to understand cognitive sense making. The topics that social cognition covers ranges from cognitive social cognition to social cognition. So, topics such as causal attribution, understanding of attitudes, social schemas, unconscious cognition about social situations, the use of mental shortcuts or heuristics in decision making, social identity, and stereotyping processes are some of the topics. In addition to this, a large number of social cognitive psychologists also understand collective sense making in terms of social representations.